CV140751 is now in session.
Good morning. Thank you. You may be seated. We're here this morning in the case of Calderon versus Menenga. It's our case number CA CV140751. These proceedings are being audio and video recorded, so we request that you identify yourself and your client when you approach the podium. Each side has 20 minutes for argument. Counsel for appellant will be responsible for reserving any time you wish for rebuttal. We have read the briefs. We've conferenced this matter. And with that, we're looking forward to your argument. You may proceed.
Good morning, judges. My name is Bill Begley. I'm here representing the defendant appellant, Kimberly Menenga. Procedurally, which I'm sure the court is very familiar with, what I think is important in this case is that this was a tort motor vehicle case which was certified for compulsory arbitration. It went through the arbitration process. The arbitrator found in favor of my client, the defendant, and awarded 0 to the plaintiff. The plaintiff then filed a notice of appeal to the Superior Court. That case was set to go to trial in October of that year, and in August, the plaintiff's attorney filed a notice of voluntary dismissal under Rule 41A2, and the trial court signed a proposed form of order, which is what brings us here today, Your Honors, in terms of the issue we're presenting to the court. First is that the plaintiff's motion to dismiss pursuant to Rule 41A2 should have been subject to a hearing on that motion, and I believe everyone agrees that no hearing was held in that regard.
Counsel, tell me what that hearing would look like.
Your Honor, I believe it would be simply an evidentiary hearing at which either side would have the opportunity, particularly from where we're going with this case, to cross-examine the plaintiff in terms of economic hardship, find out what resources are available.
Well, you mentioned cross-examination, but what if the plaintiff chose not to testify? I mean, no party requested an evidentiary hearing. You agree?
We did not have time to. I agree, Your Honor.
Well, help me on with that, because you filed an opposition to the motion.
Exactly, and the order.
Requested oral argument.
Yes, Your Honor, and the order was signed before there was any oral argument either set or scheduled by the court.
Help me then further understand that you didn't have time to request an oral argument or to request an evidentiary hearing. Wouldn't that typically be made in the opposition to the motion itself?
And I suppose in that regard, Your Honor, by filing an opposition, we would be asking for that hearing. The case.
Why would you necessarily be asking for a hearing? You might have a basis that's independent of some evidence that you would want to put on. It seems to me a request for an evidentiary hearing is something that's a standalone request that can be made or not made. Sometimes the parties agree that there are undisputed material facts, but they're entitled to relief on something. But courts don't like to just set hearings if neither party requests one.
I understand, Your Honor, but of course what we've cited in our briefs are 2 Arizona Supreme Court decisions, Goodman v. Gordon and Cheney versus Superior Court.
But assume they both hold that a hearing is required. Courts don't hold hearings if the parties don't request it. They're required if the parties need one, if there's a need to develop evidence. The fact that it says that you would get a hearing, isn't it sort of implicit? You get a hearing if there are disputed facts. If they're not disputed facts, and if the parties don't alert the court to the fact that there are disputed facts, why would a court just on its own set an evidentiary hearing?
Well, Your Honor, I believe we alerted the court to the disputes in that response in opposition to the motion to dismiss.
Well, but I'm still confused why you didn't specifically ask for an evidentiary hearing.
Your Honor, I believe our hope at that time was that in opposing the motion and requesting oral argument, that the court would set the type of hearing that we needed.
But you could have had purely the legal basis for arguing that the motion to dismiss was improper, and you would need an evidentiary hearing for that. The court doesn't know that. I mean, the court doesn't know whether you need to have an evidentiary hearing or not unless you alert the court to that.
But, Your Honor, I believe the case law, and we've also cited cases like United States versus E.I. DuPont, they talk about how in a Rule 41A2 setting, not A1, but A2, this case, you have to act as an equitable court. You have to balance all of the substantial legal rights of the defendant as well as the plaintiff moving for the dismissal. In that regard, Your Honor, I think that's why the case law like Goodman and Cheney is so absolute that before you can grant that motion to voluntarily dismiss, there must be a hearing.
But let me ask you, is it your position then, before a Superior Court could ever grant a 41A2 motion, that it would not only have to have an oral argument, would it have to set an evidentiary hearing?
Your Honor, I believe you'd have to have one or the other. I could see where the oral argument would act in the place of the hearing.
Why would that be? If the hearing is to offer evidence, why would it be one or the other?
I'm sorry, I stand corrected, Your Honor. I understand.
I
understand what you're saying. In order to try and get one or both parties there to discuss what the substantial legal rights are of each side, I understand the hearing would be the proper process to be able to either offer that testimony or simply not present the trial court with any such evidence and then be able to challenge the trial court's ruling on the absence of meeting that burden.
And so help me out again, if your view on appeal is that an evidentiary hearing was required, had to be held here. Trial court could not have done what it did without an evidentiary hearing. Is that correct?
Short of both sides stipulating and agreeing.
And tell me, when I asked what that evidentiary hearing would look like, you had indicated that you would have an opportunity to cross-examine the moving plaintiff.
Yes.
Anything else from your perspective?
I believe you could also simply offer the testimony of your own client in terms of giving the court a view of the equities of the plaintiff doesn't have all rights. The defendant certainly has rights within our system.
Well, no, and I understand that, although that could have been an affidavit in an opposition. I mean, you knew plaintiff was wanting to walk. That was not a surprise. And if I remember right, and I'm trying to think which of the two cases that you cite this happened, it was a bang-bang. The motion to dismiss is filed, and before the other side gets a chance to even file an opposition, the motion is granted. And that's a very different world than we have in this case.
Well, Your Honor, I guess we also would have been offering the evidence that we put in writing in terms of why our discovery efforts were what they were and what those costs were in terms of, I'm sure the court remembers our discussion in the pleadings as well as the briefs of this tripartite agreement and algorithm in order to defeat what is reasonable and necessary medical treatment. So I suppose if the court had said I have questions with regard to that level of discovery, we simply could have perhaps by that time gotten our 30A depositions.
Well, and it seems to me, and you raise a good point, trial court had a lot, it would seem, of practical options here. Now, your point is legally the trial court had very few, but practically the court knew that your client was not wild about this request, to state it mildly, that your client opposed that, and you made that very plain in the opposition of the motion, and then in a subsequent sort of set of motions saying, hey, Judge, you should undo that. And to the extent the court believed that it needed either oral argument, which clearly was requested, or I suppose sua sponte, set an evidentiary hearing, trial court absolutely could have done that, but chose not to. And had the court entered an order that imposed upon plaintiff as a condition of dismissal, remember we're, as you know, 41A2, not 41A1, which is a very different sort of process, trial court could have said, yes, I will grant your motion, but given where we are in this case, given where we are to trial, it's going to cost you some because the other side has incurred its own expenses. And that perhaps is a more typical outcome in a motion like this, perhaps not. But your point, I think, requires an argument that at all those phases, the trial court didn't have discretion to do what it did. Is that fair?
That's correct, Your Honor.
Okay. And that's based on the two cases that you cite and the others saying a hearing, whatever that phrase means, is required.
Yes, Your Honor.
Okay.
Exactly.
Let me ask, and I don't want to get tripped up on this, but this was a dismissal without prejudice. And setting aside special action jurisdiction for a minute, tell me why we have appellate jurisdiction.
Your Honor, once the order which was signed and filed dismissing the case, once that went in, I'm sure the court saw our attempt to move for a new trial through an inadvertent legal assistant error that missed by a day because on the day it was due, she filed in the wrong case number. We tried to correct it as quickly as we could, doing a Rule 60C motion for reconsideration. But as the court well knows, that does not toll the time for appeal. So we were up against that clock running, and that's why we put the notice of appeal on file.
And I understand that. My question, though, is typically a dismissal without prejudice is not an appealable order. And that, it seems to me, that's what we have.
Except in this case, Your Honor, I believe you have complete finality to the underlying proceeding.
Well, but by definition, a dismissal without prejudice wouldn't preclude the plaintiff, and I'm not suggesting this, believe me, reinstitute the complaint either in a different form or on a different day. And
the motor vehicle accident happening in 2011.
I'm not saying there wouldn't be defenses to that. I'm just, there is case law in this court saying for appellate jurisdiction, again, setting aside special action jurisdiction where the court has sort of more, I was going to say freedom, that's probably a bad word, but more flexibility. But typically, the court does not have appellate jurisdiction over dismissal without prejudice.
And I'm sure Your Honor saw that we gave consideration to the idea of coming into this court and then perhaps having the matter revested, because it looked like at times the judge after the fact was sort of interested in setting some type of a hearing. However, when we saw the substantive errors, and those are in terms of what we were asking for, in that regard, the trial judge really, in our opinion, had no discretion to not award certain items, and that's where we get into our costs argument, our Rule 68 argument.
And can I ask, on your Rule 60 motion, which, as I recall correctly, was admittedly timely, it seems to me that, and that was set for oral argument, but I think at your request, the oral argument was set aside or was vacated. Is that effectively either denied or abandoned?
No, Your Honor. Initially, it was the plaintiff who actually advised the trial court that, and to my best belief, using the words of counsel, my opponent here, you're divested of jurisdiction. And we cited a case in our brief where motion for reconsideration was filed, notice of appeal was filed, and the court ultimately held, I don't care if you did rule on the motion for reconsideration, you were divested of jurisdiction. Then later, when we saw, as I said, the substantive errors, when it looked like it might be reset, we made our decision at that point that these issues were so important that it would be best to bring them to the Court of Appeals.
Thank you.
And in that regard, and I'll go through this very quickly with the Court's permission, the costs awarded under ARS Section 12-341, the magic word shall is in there. And so we had made our request. We received them after the arbitration. We sought the costs additionally in the material we put in front of the judge at the time of the Rule 41.
That contingent at all on there being a final judgment on the merits? And does a dismissal without prejudice satisfy that?
I do believe in this case there is the final judgment and therefore the opportunity to move for those costs. And once that's in place, I don't believe there's any discretion with the trial court.
But if there's not a final judgment, then the rule doesn't apply.
I believe I'm going to stick to my guns, Your Honor, that there is the appropriate appealable order in terms of its finality. As far as Rule 68, the same type of mandatory language is in there. With the cost statute, we cited the case that holds there's no discretion. With Rule 68, we cited the Levy case, no discretion. And in that regard, what we were seeking was the sanction of double costs. This court knows the purpose of Rule 68 is to encourage settlement and avoid protracted litigation. In a situation like this, if the plaintiff can take this case all the way along in the trial system and then suddenly walk with its own proposed form of order, certainly that is defeating the purpose and public policy behind Rule 68. Rule 77 is perhaps a little more.
Isn't there a way to solve that, though, given that the trial court does have discretion to award costs in granting a motion to dismiss? So that would still, you don't necessarily have to have these other rules. If on a dismissal without prejudice, the court has absolute discretion to award fees and costs. Certainly, in this case, it presumably may have been appropriate to do so, but the court had discretion to do that, particularly in light of the award from the arbitrator. But that seems to be the way to address the issue, is in asking for them upon a motion to dismiss without prejudice, to ask that be a condition.
And we put our application on file. Costs, Rule 68 sanctions, attorney's fees under 77F. There's overlap, obviously, between the rules in terms of two of them are deemed by our court system as sanctions and 12-341 as simply the costs. But we didn't. What we did is say 12-341 establishes the costs, 68 establishes double costs, and clearly here the $500 offer of judgment that was filed, a lawsuit filed in March, the OJ going in September, could have saved an awful lot of protracted litigation in this matter. And then when you get to Rule 77F, where the purpose as stated in the law is to discourage marginal appeals, here you have a perfect case for that. If you return back to the facts of the case in the record, this is contact between two vehicles resulting in $14.40 of property damage.
But what if a trial court concludes that one side or the other's costs were unreasonable, that they incurred costs that may not have been necessary? A court has discretion to do that, I assume?
Yes, Your Honor.
So why isn't that encompassed as part of the court's ruling when the parties ask for cost in the context of ruling on the motion to dismiss. If the court, couldn't we conclude that the court made the determination there that the cost may not have been warranted? Does the court have discretion to do that?
I don't know, though, if Your Honor, as the Court of Appeals follows that type of a standard of review where you're going to speculate as to what the trial court did. Certainly, if the trial court had had some type of hearing, as we've been asking for, there could have been statements on the record, a more detailed finding than signing off on a proposed form of order that just says each side to bear their own costs and fees. So I think there never was a challenge to the application that we filed. You won't see anything filed by the plaintiff in the underlying litigation suggesting that the costs or any element of them were unreasonable. With the court's permission, I'd like to reserve my remaining time for rebuttal, please. Thank you.
Good morning, Your Honors. Jules Grandjean for the appellee, Nathaniel Calderon. And I definitely want to get to your questions, which I'm sure there are many of this morning, but I'd like to start with a question of my own, which is, why are we here? And the appellant has told you, well, the judge's order is what brings us here today. And I don't find that entirely true, because the judge's order, which he entered, was for a hearing to be held, oral argument to be given. In fact, a date was set over a year ago, January 30th. I was present for that, and I put on my calendar at that time that I would be present for that hearing, and I was prepared to proceed.
That hearing or an oral argument?
Well, I have in the minute entry that actually will be heard at oral argument, as what's stated in the November 13, 2014 minute entry. An oral argument would be on, among other things, Defendant Menenga's verified statement of costs and notice of taxation, defendant's application for attorney's fees pursuant to Rule 77F.
That's an oral argument. It's not an invitation to present new evidence, right?
Your Honor, I don't understand one way or the other what was intended specifically there. So far as I do understand, it's intended to address these things that seem to be complained of here by the appellant, that they were.
But it seems to me to be very, very significant that if there's only been a request for oral argument, and if we're suggesting there's prejudice in this case from not granting an oral argument, that's very different than prejudice from not granting an evidentiary hearing. Not granting an oral argument means we just rely on the pleadings in front of us. It doesn't change the evidence that's considered by the court. So to me, it is significant that the court apparently just had set an oral argument and that there was no request for an evidentiary hearing.
I would agree with you there. I don't know if there was a request for an evidentiary hearing per se, and I don't know if that's what's required under Goodman versus Gordon. In any case, I think a fair opportunity would have been presented to them to argue these issues and then appealed.
So what happened after the entry started the oral argument?
If their issues were not addressed at the oral argument or following oral argument on some sort of order, then an appeal might be appropriate. I think what happened here, and I've been trying to answer the question myself as to why we're here, can be seen in their prayer for relief, which isn't just grant us the hearing down in the lower court. They're saying, well, grant us that hearing, whatever that means, and direct the lower court to enter costs, our attorney's fees, and so forth. So it's an end run basically around the trial court. They had an opportunity for this hearing. In my view, their concern is that they cannot prove that taxable costs and so forth are reasonable or warranted. And the key, you've brought it up on several occasions now, is discretion. That's the key word here. Even if we assume everything appellant is saying is true, that they bested the offer of judgment, that on an appeal from arbitration they're entitled to attorney's fees. Even if we take all of that as true, the court still has discretion to figure out what those are going to be. Under Rule 77F2, it's explicit. For attorney's fees, that's the trial court's province to determine those. If we take the offer of judgment, for example, the taxable costs we're talking about here, and double taxable costs as sanctions. If you look at Reyes versus Frank's Service and Trucking, Fowler versus Great American Insurance Company, costs have to be reasonably necessary incurred. Just like they're complaining here, hey, Calderon's medical bills may have been reasonable and necessary. He's got to prove that. He can't just submit a bill and we just pay it. They've got to do the same thing. We don't just take at face value that they have a bill of costs and therefore they should be paid.
Hadn't the arbitrator already awarded costs against your client?
That's correct.
And I understand that's subject to de novo review, but isn't that some hint that the reasonableness issue had been resolved adverse to your client?
I wouldn't agree with that, Your Honor, that he examined the reasonableness or necessity of costs. He had a proposed form submitted to him, which we did not object to at the time because we intended to appeal and have de novo review. But I don't think that was examined, and I didn't see it explicitly laid out in any form of his decision.
But you're not suggesting an arbitrator in a case like this is required to make findings of fact on reasonableness of costs, are you?
I don't know if that's what I'm suggesting, no, Your Honor. The other thing I would mention, however, is that he also only looked at the costs up until the point of arbitration.
Right, but I don't know which way that cuts. Your opponent would say, yes, that's right, that's an absolute floor, and in fact their costs far exceeded that because a bunch of other litigation occurred after the arbitration award.
Your Honor, I think that the costs need to be explored for reasonableness and necessity pursuant to the case law, at least if they're going to be awarded finally by the trial court, and the trial court has that discretion.
Isn't it abuse of discretion when zero costs are awarded? There's presumably some costs, but it's hard to say that it's everything the defendant did was unreasonable. They certainly had to incur some costs just to address the complaint. Does it approach an abuse of discretion when nothing is awarded?
I couldn't speculate as to that. Again, that would be for the trial court to determine, Your Honor. I would anticipate at least the answer fee would be reasonable and necessary, that they would have to appear. But in terms of other things, and explicitly what we're talking about here are numerous deposition costs that they took under their theory of some scheme or otherwise.
But here it's zero, and understanding that the trial court has broad discretion, does that leave any room for this court to review that decision?
Your Honor, I think the rule is written that way for a reason, and that is to catch all situations, including if a trial court thinks there's been some abuse of the system by the appellant, and whether what they're doing is proper, whether they're using or gaming the system. The trial court then does have discretion to award zero, and that can be an outcome. That's what they're complaining of here, that, gosh, this will happen, an appellant or a plaintiff shouldn't be able to appeal an arbitration award and then just walk scot-free before trial. Well, that probably won't happen in 99% of situations, but it might, and there might be a situation that calls for that. And this might be that situation. And the trial court was in the best position to see what was occurring, that these motions were being filed for more depositions 2 months before trial. You know, they bring up the point that we dismissed the case about 2 months before. They were going to take more depositions.
But it went to the arbitrator, and there were costs that the arbitrator found. And at that point, the reason it continued was because your client filed an appeal from the arbitrator's decision. So it's hard to understand why there were no costs awarded, at least to those that were occurred up through the point of arbitration, where if we're looking at it just as an abuse of discretion standard.
I don't know the explicit reason for that, and only the trial judge would know that, and he'd be in the best position to assess that.
Isn't the implication of your argument, though, that had the trial court awarded, and I think the full freight is somewhere around $21,000 in fees and costs, that would not be against your client, that would not be an abuse of discretion as well?
I'm sorry, I don't understand your question, Your Honor.
You are, if I hear you right, and I think there's a response on whether costs are discretionary or not, but let's set that aside for a minute. You're saying zero is not an abuse of discretion. Well, that if the trial court has substantial discretion in awarding costs, wouldn't the argument be the same had the trial court here said, yes, you can get your dismissal under 41A2, but it will cost you $21,000?
Yes, that's correct. The trial court has discretion to award $21,000 or zero.
And help me out on the discretionary side, because it seems to me in this case, the trial court has at least some discretion in determining who the successful or prevailing party is, because if you look at the case, it may not be readily apparent. But isn't the taxation of cost, setting that issue aside, isn't that taxation of cost typically a pretty cut and dried thing? Tell me about the reason why you argue that the trial court has discretion in awarding specific items of cost, for example, like the answering fee.
Sure. Your Honor, that's found under Reyes versus Frank Service and Trucking and Fowler versus Great American Insurance. In the quote we put in our brief is, trial courts have broad discretion in setting the amount of a taxable cost award and should consider the need for the expenditure and its reasonableness. So again, I appreciate that there's shall language that's being brought up here under 12-341 and so forth, but under Harris versus Reserved Life, you're right. The trial court also has to assess who a successful party is. In that case, explicitly says in the event of dismissal, it may be the defendant, it may not. So we don't even know whether the defendant's to be considered successful. If they are, the trial court has broad discretion in examining all taxable costs under Fowler versus Great American Insurance. I can't say what it would or wouldn't do, but it does have that discretion and that right in my view.
Tell me, if you would, briefly, or I'd like to hear from you on, and again, setting aside special action jurisdiction, but appellate jurisdiction.
Your Honor, in my view, there isn't, well, I raised the possibility with the trial court that they might be divested of jurisdiction. That's what I put in our motion before we had the hearings to make sure that any decision it made was okay. I wasn't entirely sure about that. In reviewing your jurisdiction comes from judgments, basically. Judgments that are final are reviewable in this court. Whether a dismissal that results in a without prejudice order, I don't know whether that is a judgment or whether that results in appellate court jurisdiction. I'm not sure that it is a final judgment on the merits, and that's what's been argued as well.
If you chose to, your client could reinstitute a complaint, right?
I'm sorry, Your Honor?
And so if your client chose to, your client could institute a new action, right?
Yes, he could. That's true, and there would be quite a number of defenses that would be raised
For
against
sure,
it.
but that wouldn't make a final, would it?
That's correct. He could reinstitute the action.
So if we only consider final actions, then this isn't final.
Then technically there wouldn't be jurisdiction here, Your Honor.
Counsel, let me ask you to address the Cheney and the Goodman directive. It's fairly crisp, and I'll quote it. The right to dismiss after an answer has been filed, however, is discretionary with the trial court and must be made by motion with notice to the defendants, a hearing, and a court order. And in many respects, that's kind of the crux or the pivot upon which this appeal turns. Heard from your opponent. I'd be happy to hear from you on that point.
Well, Your Honor, in our view, they were given a hearing. It was just on the pleadings, what they submitted to the court. They had an opportunity to submit their application for fees and costs and so forth. The court was going to grant them an opportunity to hear that orally. If we want to talk about an evidentiary hearing, I don't know exactly what would be presented. Hearing is not something that I could find ever defined by the legislature or the courts up until this point in our state. They tell us, if that hasn't been defined, you look at the restatement, basically, to fill in the void when we talk about tort cases. I didn't find anything in the restatement that was helpful to that. I know from administrative law, hearing is often done on paper, seldom actually done with an opportunity.
Doesn't a hearing suggest an opportunity to present evidence?
It does,
Which
yes.
is different from simply an argument. An argument is simply a chance to argue regarding the evidence that has already been submitted.
Yes, and I don't know what new evidence other than what's been submitted to the trial court in their application for fees and costs. Same things that they've included all those papers with their appellate brief here in the appendix. I don't know what new would be presented in terms of evidence by the defendant. I don't think there is anything there. But
And I guess the question is whether the trial court is sua sponte required to set a hearing.
I don't think that it, well, yeah, that's a good question. I don't think that it would be, but I don't know that. I think it'd have to be requested. You could read Goodman the other way, I guess. But, that's something I couldn't find any helpful directive in the law, so I can't be helpful there. Well, if you don't have any other questions for me, I'll save you the rest of the time here. Thank you.
And now the 34-second rebuttal.
We'll give you a minute.
Thank you, Your Honor. In terms of the response to plaintiff's motion to dismiss lawsuit that we filed with the trial court on September 2nd, on page 2, carrying over to page 3, it says, granting a motion to dismiss is discretionary with the court, but a hearing is required before such a motion can be granted, citing Goodman versus Gordon. To me, that's the request for the hearing. As far as the finality of what occurred down below, again, Your Honors, what I see is an order signed and filed dismissing the lawsuit. There was nothing left to do. The trial court obviously wasn't going to entertain anything further by us. To me, that is at least a final order and summons upon the appealability of that order. As far as discretion, we've had that discussion going on. The reasonableness of costs, I think we all agree the trial judge has that discretion. But Judge Thumma mentioned a couple of costs that how can there be an argument of reasonableness, an answering fee? We've submitted, which is at index of the record, item 65, the costs that we sought. Some of them are turbo court filing fees, subpoena fees, and the way you find that those are appropriate is you turn to ARS section 12-332, where the costs that you can recover are defined. In terms of the judge had all the papers before him, I think the court has already made that point that that's not an evidentiary hearing, and we cited several cases that talk about solitary deliberations are not the equivalent of that type of a proceeding. Finally, Your Honors, the reason we come before you today is what we placed in our brief early on, and that is in terms of these sanctions under 68 and 77, in terms of the purpose to be served by those rules, if a plaintiff can file a lawsuit, participate in an arbitration hearing, lose the arbitration, appeal the award, and then a couple of months before trial, walk away from the lawsuit without being subject to any consequences whatsoever for appealing the arbitration award, it's going to turn the system on its head. Defendants are going to battle that over and over again. Our conclusion sets forth our request for help, Your Honor. Thank you.
Thank you, counsel. Thank you both for your argument. We will take this matter under advisement and issue a decision in due course. We're adjourned.